all rise.
Would you call the matter, please?
In the Supreme Court of Western Australia, CIV 103 of 2017, Peter Baelish and Sandor Clegane and Brienne Tarth.
Yes. Mr. Lannister?
May it please the court, I appear for the plaintiffs.
Yes. Ms. Targaryen?
May it please the court, I appear for the defendant.
Yes. Mr. Lannister?
Your Honour, before you there are two applications. One is an application by the plaintiffs dated the 17th of November 2018 for an extension of time to file and serve the statement of claim, and the other is an application by the defendant dated the 18th of November 2018 to dismiss the action by reason of the plaintiff's failure to serve and file the statement of claim in accordance with Order 20, Rule 1. Subject to Your Honour's view, it is proposed that the applications be heard together.
Yes. I think that is the appropriate call.
I don't know whether Your Honour has had the opportunity to read the relevant papers.
Yes. I have read them, but you will need to take me to the specific parts of the affidavit evidence on which you place particular reliance.
Yes, Your Honour. I was proposing to do just that. Your Honour will have seen that 3 affidavits have been filed in support of the plaintiff's application. An affidavit of each of the 2 plaintiffs sworn on the 16th of November 2018, and an affidavit of their solicitor, Mr. Slowe, sworn on the 17th of November 2018. The plaintiffs rely on those 3 affidavits.
Your Honour, before my learned friend turns to the affidavit evidence, I should mention that we object to parts of the affidavit of the second named plaintiff, in particular to paragraphs 6, 7 and 8, on the grounds that they are inadmissible hearsay. The source of the information relied upon in those paragraphs has not been identified, and accordingly, Order 37, Rule 6, Sub-Rule 3A, has not been satisfied.
Mr. Lannister, there seems to be a problem there, doesn't there?
I do accept that, Your Honour. We do not seek to rely on those paragraphs.
I think they should be struck out.
Yes, Your Honour. Your Honour, before I turn to the affidavit evidence, can I just remind you of the factual context in which these applications have been made? I don't think any of this is controversial. However, Your Honour will recall that the writ was filed and served on the 14th of August in 2018, and an appearance entered by the defendant on the 21st of August in 2018. Under Order 20, Rule 1, the statement of claim was due to be filed and served on or before the 4th of September 2018. This did not occur, and on an application of the plaintiff on the 18th of September in 2018, Your Honour extended the time for filing and service of the statement of claim to the 2nd of October 2018. Regrettably, that time limit was also not met, and there then followed a course of correspondence between the solicitors and the parties in which the plaintiff sought agreements on a new date. That correspondence is attachment A to the affidavit of Henry Quick, the first named solicitor. No agreement could be reached, and in a letter dated the 7th of November 2018, which is to be found at paragraph 17 of Mr. Quick's affidavit, the solicitors for the defendant foreshadowed an application to dismiss the action by reason of the failure of the plaintiffs to comply with Order 20, Rule 1. It is apparent that no agreement on a further extension of time was possible. This application was brought by the plaintiffs. It was followed very quickly by the defendant's application. Your Honour, the principles to be applied on the application for an extension of time are well established. They are set out in number 2 of my list of authorities, but I'm sure that Your Honour is very well familiar with them. In short, the relevant factors are the length of the delay, the reason for the delay, the plaintiff's prospects of success in the action, and the extent of any prejudices to the defendant if the time limit were to be extended.
Those factors are not necessarily exhaustive. However, I am called upon to exercise a judicial discretion, and the ultimate question is what, in all the circumstances of this case, is in the interests of justice. For instance, a further factor of significance in some cases is the effect on other cases waiting their turn in the list, although that may not be a factor of any real weight in this application.
I accept that, Your Honour, but in my respectful submission, the factors to which I have referred are the principal factors that will guide Your Honour in the exercise of discretion in the circumstances of this case itself. I should add that the effect of other cases waiting their turn in this list is not actually in my submission a factor of any significance in the present case. If I can turn then to the evidence. Your Honour will see that at paragraphs 7 to 13 of his affidavit, Mr. Quick sets out a series of medical calamities that have recently befallen him and which explain the reason for this delay.
calamities might be over-egging it a bit, Mr. Lannister.
Well, Your Honour, I concede they are not life-threatening conditions, but nonetheless they are painful and unpleasant, as well as being of a kind that would understandably prevent Mr. Quick from being in a position to give adequate instructions to his solicitors to enable the preparation of the statement of claim. Mr. Quick has, for instance, on 3 separate occasions in the last month, had to attend the emergency department at Fiona Stanley Hospital for urgent treatment, and he is on strong painkillers, which he says seriously affect his ability to concentrate or read for a sustained period of time.
There is no medical evidence?
No, Your Honour, but in my respectful submission, the evidence of the effect of Mr. Quick's medical condition and the medication that he's taking for it sufficiently appears in his own affidavit. The evidence of the second named plaintiff, his wife, Ms. Quick, is that she was not involved in the day-to-day running of the business and that she is therefore not in a position to give proper instructions to their solicitors. That appears from paragraphs 3 to 5 of her affidavit. The evidence of Mr. Slowe, their solicitor, is that he does not have sufficient instructions at this stage to prepare the statement of claim. That appears from paragraphs 3 of his affidavit. Your Honour, the evidence of Mr. Quick at paragraph 14 of his affidavit is that he will be sufficiently recovered to provide instructions for the statement of claim in about 7 days. Mr. Slowe's evidence at paragraph 4 of his affidavit is that he will be able to file and serve the statement of claim within 7 days thereafter. In those circumstances, the plaintiffs seek an extension of time to the 21st of November in 2018 to file and serve the statement of claim itself. I understand from my learned friend that for the purposes of this hearing, it is not an issue that the plaintiffs have an arguable cause of action against the defendant, as deposed to in Mr. Quick's affidavit at paragraphs 15 to 24. On the question of prejudice to the defendant, there is no affidavit evidence from the defendant deposing to any prejudice if an extension of time were granted, and nor is there any basis upon which relevant prejudice could reasonably be inferred. The evidence in issue in the action are recent, and there is no danger of memories failing or any reason to expect that the availability of witnesses would be affected by such a short delay.
Thank you, Mr. Lannister. Ms. Targaryen?
Your Honour, in my respectful submission, the plaintiff's application lacks any proper basis. As my learned friend has mentioned, the statement of claim was due to be filed and served on or before the 4th of September 2018, and it was not. An extension to the 2nd of October 2018 was sought by the plaintiffs and granted. However, that was not complied with. Up to that stage, no mention had been made of the medical condition, which Mr. Quick now says has disabled him from giving instructions for the statement of claim. It was first raised in subsequent correspondence, which is contained in Attachment A to Mr. Quick's affidavit. It is an explanation that, in my respectful submission, Your Honour should not accept. As Your Honour has noted, there is no expert medical evidence as to the effect of the alleged medical condition, or as to the effect of the medication which Mr. Quick says he is taking to alleviate it. Nor is the absence of any such evidence explained. Your Honour is asked to rely on Mr. Quick's own lay opinion as to those crucial matters in circumstances where no reason has been offered for the absence of the expert medical evidence which Your Honour is entitled to expect would be adduced. The absence of such evidence is of particular significance in the present circumstances, where the medical conditions themselves are not of a nature that would ordinarily be expected to have the effect they are now alleged to have. A torn ligament and an infected wound in the thigh are not injuries that would ordinarily affect a person to such an extent that they would be unable to give instructions to their solicitor to prepare a statement and complain. The delay has already been substantial. If the application were to succeed, and if the further extended deadline were to be met, the total delay would be over 3.5 months. And I say if the further extended deadline were to be met, because we only have Mr. Quick's layman's assessment that he will be sufficiently recovered to provide instructions for the statement of claim in about 7 days. We therefore face the prospect of a further application for an extension if that bush medicine should turn out to be too optimistic. Again, the expert medical evidence that might have provided some assurance in that regard has not been adduced.
Your client does not allege any specific prejudice?
It is true that there is no direct evidence of prejudice to the defendant were the extension to be granted, but in my respectful submission, it is well accepted that there is inherent prejudice to a defendant in having litigation hanging over his head. If authority is needed for that proposition, it is to be found in number 2 on my list of authorities. In this case, As a result of the plaintiff's delay, the litigation will be hanging over the defendant's head for an unnecessarily long time. Nor does my learned friend's submission deal with the objectives of Order 4B, which are to ensure, among other things, that litigation is conducted so as to minimise delay and costs. The approach the plaintiffs have taken to this litigation to date reflects an inability or an unwillingness to conduct the litigation in that way. In my respectful submission, the delay to date has already been substantial. It has not been satisfactorily explained. The court has been given no adequate basis to believe that litigation will henceforth be pursued with proper expedition, and as a result of the delay, the defendant has been, and will continue to be, put to the inherent prejudice of having this litigation hanging over his head for an unnecessarily long period. In the circumstances, the plaintiff's application should be dismissed, and the action should be dismissed with costs. Those are my submissions.
Thank you, Ms. Targaryen. Ms. Lannister, anything in reply?
No, Your Honour.
I will reserve my decision. Thank you both for your submissions.